ADR-LINK is a program of the London Family Court Clinic and matches families referred for service to qualified ADR practitioners. The practitioners are not LFCC employees and do not work for Children's Aid Society offices. They are independent, impartial professionals trained to assist families and CAS to work towards resolutions that will focus on the best interests of the child or children.
As we forge forward and continue working with Indigenous nations, we want to first acknowledge, respect, and recognize the deep connection and historical relationship Indigenous peoples and the land we share. With support, accountability, and much respect to the following traditional homelands and territories of the Anishinaabe, Ojibwe or Chippewa Nation, Haudenosaunee, people of the Iroquois, which includes the United Nations, Lenape, also known as the Delaware, and the Attawandaron, also known as the Neutral, the Wyandot, also known as the Huron. There are 11 First Nation communities in the region of southwestern Ontario and over 120 First Nations in all of Ontario.
Alternative Dispute Resolution, most often referred to by its acronym of ADR, came into being in 2006 when the Child and Family Services Act, as it was then called, was amended to stipulate that Children's Aid Societies must consider ADR for children who are or who may be in need of protection. ADR is a strategy to streamline court processes and encourage alternatives to court. It focuses on a strengths-based, inclusive, and collaborative approach to resolving child protection disputes and encourages the involvement and support of the family, extended family, and the community in planning and decision-making for children and their families when they are involved with the child welfare system. There are 3 main prescribed methods of ADR: child protection mediation, family group conferencing, and original dispute resolution, which is sometimes called Indigenous approaches to ADR. Let's look at an overview of openness in adoption. One point in child welfare where ADR has proven useful is in openness. Openness is a shorthand for the process of working out what kind of contact will happen between a child and important people and communities that would otherwise be lost once a child is adopted. Adoption is the permanent legal transfer of all parental rights to another individual or couple. The adoptive parent legally, emotionally, and unconditionally accepts the child and has the same rights and responsibilities as parents whose children are born to them. After adoption, birth parents no longer have any legal rights or responsibilities in respect of the child. Traditionally, adoptions were closed, and the child typically no longer had any connections to their birth family, and often, in the case of Indigenous children, no more connection with their heritage or communities. Today, the more common approach is open adoption. Open adoption occurs when there is some form of communication or contact between the adoptive family, the adopted child, and the birth family after the adoption has been finalized. Contact and communication can range from an infrequent exchange of letters and pictures, perhaps through a neutral third party, to face-to-face contact between the child and birth family or community. Consideration of open adoption should be a part of the decision-making process for every child whose plan is changed to adoption or where a concurrent plan of adoption has been established. Open adoption should be pursued unless it is not in the best interest of the child. The participants in negotiating openness must understand that an open adoption is about a child's right to maintain significant relationships. Openness allows a child and the person with whom the child has openness to communicate with each other and exchange information. It also allows the child access to important medical information which may become relevant as the child grows. Mediation between the birth family, adoptive parents, and other important community members is the best way to achieve an agreement that will benefit the child. The child's views and preferences, when they can be ascertained, must also be taken into consideration. Ideally, the openness agreement or order will reflect that the child's views and preferences will be taken into consideration as the child ages. In order to negotiate what openness is going to look like, a referral to ADR is a great solution. Most openness matters using ADR will be referred to child protection mediation. If the child is First Nations, Inuk, or Métis, the file could be referred to original dispute resolution. Research, as well as anecdotal accounts from adoptees, birth families, and adoptive families, broadens our collective understanding that adoptees need to understand the circumstances surrounding their adoption and know of their birth families to increase their sense of stability. Openness allows a child to know their ancestry and feel connected to their cultural lineage. As in all things, the best interests of the child in developing these arrangements is paramount. The level of openness in adoption is decided on a case-by-case basis by those involved and may include birth parents, siblings, and/or relatives. Best practice calls for openness arrangements to be mediated between adoptive and birth families. These arrangements are then put into either a court order or an agreement. Ideally, these arrangements should be driven by the adoptive and birth families, and not by legal counsel, child welfare agencies, or other parties. It will be the adoptive and birth families who will be responsible for putting any plans into action and for providing support to the child. The Office of the Children's Lawyer will usually assign legal counsel for a child. The child's counsel will meet with the child and find out the child's views and preferences. If the child is too young to communicate their views to their legal counsel, then the OCL will take a position based on the information gathered during the OCL's inquiry into the child's important relationships, and their right to maintain these relationships post-adoption if the openness is in the child's best interests. The OCL will, for example, consider arrangements for a child to maintain contact with their siblings if their siblings are placed in different homes. Sibling contact is very important to consider and is often overlooked when planning openness arrangements, so child's counsel will often identify this as an issue to be discussed in mediation. The child protection mediator will meet with all of the participants prior to the mediation and prepare the participants for mediation. The child protection mediator will review the concept of openness and gauge the participants' willingness and readiness to broach these discussions. Bringing participants together for a discussion about openness is often the first time that the birth family and adoptive family meet together. The child protection mediator, who has taken the additional steps to receive a specialization in openness, is well trained to approach the work with empathy for all of the participants, with a suitable depth of knowledge of the law, the research, and clinical considerations. Mediators are able to identify the issues which will need to be discussed to ensure that the agreed-upon openness arrangements are in the child's best interests, and ensure that the participants will fulfill their commitments to one another and to the child. Adoptive families and birth families can expect to be educated by the child protection mediator about openness regarding the benefits to the child and what it means and doesn't mean for the adults. They can also be expected to be fully supported and guided through the process, as much of this information is new to them as there are many decision points. The child protection mediator will take a neutral and balanced approach regarding the outcome of the openness arrangements. As for child welfare, their participation in the child protection mediation is paramount. By hearing from the birth family and adoptive family firsthand about the openness arrangements, the child welfare staff are well positioned to support the families and the child. Best practice occurs when the child welfare staff are able to remain neutral when explaining and supporting openness to families, and to not encourage a certain number of visits or letters only. The decisions regarding the arrangements is best left to the people who will be implementing these arrangements. Another consideration to remember is that the openness arrangements will follow the child even if the adoption breaks down in the future. Of course, this is not what anyone wants, but it does happen from time to time. The openness arrangements will reflect this possibility, by naming the child's caregivers instead of the adoptive parents in the event that the child's care arrangements change in the future. As in all mediations, any agreements made in mediation are non-binding and should be reviewed by each party's legal counsel. After review with legal counsel, if the adoptive parents and birth family are still in agreement, then the mediator's report will form the basis of the court order or agreement. For further information about ADR, please consult the ADR-LINK website, www.adr-link.ca.